Hi, who's the attorney?
Morning, Judge.
Good morning. Come down, Mr. Flores. All right, Mr. Flores, today is your
Before this plea deadline even begins, tension is already in the air. We have a defendant asking for a new attorney on the very day he has to decide whether he's taking a deal or rolling the dice at trial. The judge, a former prosecutor and defense attorney who has seen it all, and she's about to give a masterclass in how the criminal justice system really works. This isn't just about guilt or innocence. This is about strategy, leverage, and whether Mr. Flores truly understands the risk of going to trial when the evidence may already be stacked against him. Will he gamble on a jury or accept a deal that could cap his prison exposure? Let's break this down.
just, like the series, the Guns of Will Sonnet, no brag, just facts. When I would have a client, a lot of attorneys, as a part of our giving back to the community, we represent clients on the appointment wheel. What I can tell you is attorneys who are representing clients on the appointment wheel, they're not paid enough money for what they do. I wasn't paid enough money for what I do. But all of my clients, whether they were retained or appointed, they got the Cadillac service, right? I would have some clients that would get upset with me because they wanted their case dismissed. They would think that I would just be walking around with dismissals in my pocket and maybe I wasn't pulling it out and signing it for them.
That's understandable.
And I would tell them, look, I can tell the state, hey, your case is bad. This is the problems with your case. Maybe you should dismiss it. At the end of the day, if the state doesn't want to dismiss it and they want to roll the dice and go to jury trial, they can do it. Sometimes I would have clients, they would say, you know what? I want the state to offer me probation.
Yes.
The state would say, hey, I'm not giving this person probation. So the way the legal system works, this is how it works. Your attorney will review all of the evidence that's been given to them.
Yes.
When I was attorney, I would tell my client, hey, these are the good points about your case. These are the bad points about your case. If this witness is here, and if they testify to what's in the police report, state will have proved their case. Normally, right? And so then I would have clients who'd say, hey, go to the state. Let's see what they'll offer me. And I would go to the state. I would do negotiations. They would present an offer to me. And legally and ethically, I had to give that offer to my client. So I would come back and tell my client, hey, this is what the state has offered. Sometimes my client would say like, ooh, great, I'll take that. Sometimes my clients would say, hey, I'm not accepting that offer, but I'll accept this offer, which is a counter offer. Then as an attorney, I was legally and ethically bound to go to the state and say, hey, my client will not accept this offer, but this is what they will accept. Then the state, you know what they can say? All right, we'll give your client that. Or either sometimes the state would say, no, this is our offer and this is the only offer we're tendering.
So,
And then it would be the client's choice whether they accept it or not accept it. There would be some cases they would have my client on video in HGD. Their mom would have already given a statement and told somebody, that's my son on the video. And you know what I would end up telling my client? Hey, look, I am going to fight as hard as I can for you at trial. I'm going to force the case to prove their case. But maybe the only way you're going to be found not guilty, if God sends his angels down and tap 12 jurors on their shoulder and say, find this person not guilty, I have other plans for them. But I would always tell my clients, you need to look at your case objectively and look at it and then make a decision on whether you want to go to trial or not go to trial. What I can tell you is this attorney has tried cases before. What you're charged with, he's definitely tried these type of cases before. And so if you want another attorney, you are going to have to retain your own attorney. I'm sure the offer that he has tendered to is what the state is offering.
isn't that is one of the first offer they gave you?
No. Here's the thing.
Okay.
Your plea negotiations with the state
Well, remember.
are confidential.
Okay.
So you're not supposed to tell me what the offer was or what they're doing.
Excuse me. it's because I remember I had another attorney, but then I had two attorneys, which was I don't know who to remember, and then so he had an offer for me already, and
Yeah.
then so then I had to get assigned to him because he
Sometimes, let me just tell you know why?
the same offer that they offered me, he can't even go ask them.
You know why?
You know what I mean? Like no effort is what I'm saying.
No. This is what I want you to understand. Sometimes people will be appointed attorney, and that attorney, the level that they have on the wheel is like maybe a state jail. And that's what they've been approved to try. Some attorneys, they have not been approved to try third-degree felonies or first-degree felonies. So sometimes people will come to court, and like yourself, they'll maybe have a second-degree felony or a third-degree felony or a state jail felony. And the state will make an offer based upon the state jail felony or the third-degree felony. Then, out of the blue, another case will come down, and then that case will be a first-degree felony. And then the state will say, hey, he has another case that's a first-degree felony. We're not offering the same thing. You know, it's similar to if somebody is charged with unauthorized use of a vehicle. That's a state jail felony. You get appointed an attorney, and the attorney that is appointed to you is an attorney who's had the necessary trials to be approved to be appointed to a state jail felony. So everything's going fine. The state has made their offer. Then bam, a case gets indicted, and it's a first-degree felony. Let's say it's an aggravated robbery, and that attorney will come to the court and say, Judge, I'm not approved to try cases that are first-degree felonies. So then you get another attorney, and when you get that other attorney, if the state were making an offer based on the fact that you only had a state jail felony, and now you have a first-degree felony, normally they're going to change that offer, and that offer change is normally not going to.
This right here is a crucial legal reality check. The judge is explaining something many defendants misunderstand. Plea offers are not permanent discounts sitting on a shelf. They are strategic calculations based on risk. When new charges, especially more serious ones like a first-degree felony, enter the picture, the prosecution recalculates, and usually that recalculation does not benefit the defendant. Notice how the judge dismantles the assumption that the attorney somehow lost a better deal. What she's really saying is this: the system responds to exposure and severity. The higher the stakes, the harsher the leverage. So here's the real question for you watching. If your new charge dramatically increases your sentencing exposure, would you still gamble on trial or take the certainty of a cap deal? This is where legal strategy becomes survival math.
Be in your favor. So it's going to be different. So the fact that you have this attorney here and the offer is not now different, it's probably about the new case and not the fact that he has done something differently.
It was all the cases.
Yeah. Yeah.
I mean, but I understand what you're saying.
Yeah. So I will tell you, this is your attorney. Today is your plea deadline date. You need to let me know whether or not you've reached an agreement with the state. If you have not reached an agreement with the state, that is fine with the court. This is just a time where I give people your last time to perhaps come to an agreement. And then after that, you're either going to a jury trial or a bench trial. If you come to me for a bench trial, if the state proves its case beyond a reasonable doubt, I'm going to find you guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find you not guilty. And for me as a judge, whether you're charged with murder or state jail felony or criminal mischief, if it's a murder case and the state doesn't prove their case beyond a reasonable doubt, I'm finding you not guilty. If they prove it beyond a reasonable doubt, I'm finding you guilty. Because I'm just here to follow the law. You understand? So today, you need to make a decision on whether or not you have reached an agreement with the state.
So I can't have another counsel.
No. Did you not hear what I said? No.
I heard you say.
Yeah, no, you cannot. This is your attorney.
Okay.
All right? So I'll let y'all sit and discuss it, and when you're ready to approach, I'll take the matter up.
Thank you.
You're welcome. Who is here on...
Much later.
Morning, Your Honor.
Good morning. So how did it go?
I feel much better today.
All right. No cavities?
Well, they had to take a bunch of stitches out from over. And so it's still a little bit tender, but I'm not as distracted as I was yesterday.
All right, the court is calling 2025 CR 002317, State versus Roman Allen Flores. Can I have parties announced, please?
Duffy Pitlock for the state of Texas, Your Honor.
Robert Featherston representing Mr. Flores.
And are you Mr. Flores?
Yes, ma'am.
Counsel, have you received all discovery and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Is there any application?
No, Your Honor.
All right, Mr. Flores, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Your Honor, we are not exactly, I hope it's not terribly complicated. We have the one cause number ending in 317. There were 3 counts.
Yes.
So we are proceeding on count 1 and count 3. We are waiving and abandoning count 2, but because they are different punishment degrees, there's different sets of paperwork in front of the court.
All right. And are you waiving the enhancement or no?
Yes, Your Honor, the statements.
Any objection?
No objection, Your Honor.
All right, Mr. Flores, did you review the admonishments and waivers with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places? Right. So just one moment. And count 1, you're charged with evading arrest, detention with a vehicle. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And count 3, you're charged with theft of property, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand?
Yes, ma'am.
By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
In each of these counts?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as the factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
All right. In each of the pleas, the state is waiving and abandoning the repeat enhancement paragraph and count 2. In the state jail felony, they're asking that your punishment be assessed at 119 days in the Bexar County Jail under 1244. There's to be restitution, if any, payable to Javier Leonardo, and there's to be no contact with him. And count 1, the state is asking that your punishment be assessed at a cap of 10 years in the prison. There are no applications. This case will run concurrently with the other count. So they're asking that the counts run concurrently. And they are asking that there be a judgment satisfied in 2025 CR 002317, and that is count 3. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
No.
Counsel, have there been any such motions?
No, Your Honor.
Then to count 1, how do you plea? Guilty, not guilty, or no contest?
Guilty.
To count 3, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objection, Your Honor.
All right. Did you review the
And just like that, guilty pleas entered on both counts. Let's break down what just happened. Mr. Flores pled guilty to evading arrest with a vehicle, a third-degree felony carrying 2 to 10 years, and theft between $2,500 and $30,000, a state jail felony. The state waived enhancements and 1 count. That's significant. It reduced potential exposure. But here's the twist. The 10-year cap means the judge now holds full discretion anywhere within that range. This is no longer about guilt. That's settled. Now it's about mitigation. Criminal history, character witnesses, and how persuasive the defense can be at sentencing will determine whether he gets closer to 2 years or closer to 10. The broader takeaway, plea decisions are often about risk management, not just innocence. The system runs on evidence strength, exposure, and negotiation leverage. What do you think? Was taking the plea the smart move here, or should he have taken his chances at trial? If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more in-depth courtroom breakdowns that go beyond the headlines. So here's the real question for you watching. If your new charge dramatically increases your sentencing exposure, would you still gamble on trial or take the certainty of a capped deal? This is where legal strategy becomes survival math.
evidence to find you guilty, and the court will find you guilty of each count? Counsel, let me write this down. All right, counsel, it takes 8 to 12 weeks for a PSI, but if you would like to just have this come back sooner and have me give you a shorter date and you can call your witnesses, I'll ask the state for any criminal history to be given to me at that time.
Your Honor, could we ask for 4 weeks?
Yes. All right, I need a 4-week reset. And are you waiving the PSI?
We are.
All right. Ms. Abrams, no PSI. All right, so we can go off the record. This is what's going to happen on September 9th. The state will present witnesses if they have witnesses for the court. If they do not have witnesses, the only thing they're going to present to me is your criminal history. They'll present that to me. And then your attorney, if you all wish to have witnesses for me to hear from those witnesses, I'll hear it at that time. And then I'll base my decision upon whatever evidence is presented to me. The evading, since the offer is a cap of 10, I can sentence you anywhere from 2 to 10 years in the prison. And with the other cause number, if I'm following your plea bargaining agreement, then it will be a judgment satisfied under that count. Do you have any questions? All right, thank you.
Nothing, the TSC case?
Yes.